All rise. The Minnesota Workers' Compensation Court of Appeals is now in session. Honorable Chief Judge Millen presiding.
You may be seated. Thank you. Well, our first case today is Bobby Lykins. It's a petition to vacate. We have Mr. Jung here representing the employer and insurer, correct?
Yes,
and Mr. Bailey, you are representing the employee through the conservator?
Yes.
Okay. I have your motion for a request for more time. I'm going to tell you right off the bat that we're going to follow the rules for the 15 minutes. If Judge Carlson or Judge Quinn decide, or myself, that we need more time with the questions that we have before either of you, we will make sure that that time is allotted forward to complete. But rest assured that we have reviewed this file and we are prepared with questions. And so I would ask that each of you, that you have 15 minutes to make a presentation. If you'd like to reserve some time, you may do so. But we don't anticipate going outside of the 60 minutes that we have today. So having said that, this oral argument is streamlined and our audiovisual has one microphone. Each party has 15 minutes to present their position. WID number is 115591010. Today's date is December 11th, 2023. Mr. Bailey, why don't you step forward? You may begin.
All right. I'm assuming all this stuff will stay on that. Maybe not. I better put some over here. Okay. Okay, do we push a button or something, or how do we start this process?
You just began, and the technology
right.
will take care
Tell
of the
me
rest.
when I'm done, huh? All right. I'm here primarily wanting to focus on the response that was submitted here of 29 pages, okay? As I pointed out in my reply, which ended up being way more than I expected it to be, I was thinking I will be up day and night in the 15 days that I have to respond, because I'm going to have to tit for tat respond to exactly what they are doing. And I get this blizzard of fallacies that come to me. And I'm not a fallacy guy. I'm an engineer before I became a lawyer. And I don't understand why all these fallacies are used. Well, they're used to mislead the court in terms of what it has to decide. So when I wrote that document, I still didn't quite
Mr. Bailey,
understand it.
if you're going to go forward with a defense at this point, it sounds like, tell me how you believe we're being misled here at this court today on a
Okay,
petition to vacate.
that's about what I'm about to tell you.
Okay.
All right. And the burden that I have before this court is a prima facie showing. That has a corresponding obligation to rebut. And they don't get to choose what the prima facie showing is. They have an obligation to identify what it is. I tried to summarize it in a bullet point form in the clarification that starts on page 15 of the reply. The obligation of the insurer, I'll use the insurer, is to identify what the position is, what the prima facie showing is that is made. They then have to respond to the legal or factual positions that are being presented. That's what if you do the research on prima facie, that's what that constitutes.
All right, so Mr. Bailey, forget about what Mr. Jung and his client are saying, and I mean this very respectfully, what are you saying the basis for the petition to vacate is? It seems like you're saying fraud.
Yeah, absolutely.
All right, so fraud committed by, as I understand it, the employee's attorney,
Yeah.
not you, but the predecessor.
That's correct.
And Mr. Jung's predecessor,
That's correct.
and who else? Are you saying that, the comp judge?
No, no
Mediator?
way.
Okay.
No way. I defend the comp judge.
And that's what I thought so. The mediator?
The mediator, no way. She wrote a virtual invitation to let me speak. And if you review her mediation agreement, and if you review 59502 subdivision 1A, you'll find out she's more than willing to be a witness, and she can tell you about everything that she talked to them about and that she talked to my people about. And that is very important information. I've never seen a post-mediation memo that was written like that, where she is saying this person requires intense supervision. She had read the material.
So, Mr. Bailey, I think we're kind of getting to the part of it, so if you don't mind, I'm gonna hop in here. So 176521 says that a stipulation for settlement may not be valid if somebody should have had a conservator.
That's right. That's right.
092.
That's right.
Okay?
Mhm.
And let's assume for this question that you are correct, that there was reason to believe that Mr. Lykins should have been referred to district court for finding of whether or not he needed a
Absolutely.
conservator or guardian.
Absolutely.
So in your petition to vacate, page 350 something, you specifically state that it's the district court, right?
Mhm. Mhm.
Not OAH, not this court,
That's right.
that can make the finding of incapacitated under.
That's right.
4.
That's their exclusive jurisdiction.
Okay, so my question for you is, assuming that there was reason to believe, what would happen at this point? What are you asking us to do if you are correct?
I'm asking you to vacate the stipulation and to permit us to proceed with the production of evidence in two courts, the two that were defrauded, OAH and the district court. And there are proceedings pending in the district court now. And those actions will go forward under the theories that have been presented, including the statutory theories and the common law theory.
Okay, so can you tell us what is happening right now in district court?
What is happening is we're seeing the same kind of foot dragging. Basically, everybody's waiting for the decision by this court.
Okay, well, okay, so you've sent us, thank you, the order for the conservatorship and your petition. Besides that proceeding, what other specific proceeding is happening in district court?
I don't know. I'm not down here, the district court in Ramsey County, I believe, or no, Hennepin County. It's the district court in Hennepin County where that proceeding's going. And that's being handled by a different attorney.
Okay, but can you tell us the nature of the claim? Is it?
The claim is 176.82, and the other claim is under the vulnerable adult statute.
Okay, so, and bear with me, because we're not familiar with how these probate proceedings, or if this is referred to district court, how that would happen.
Right.
What I am concerned about is if this is handled by district court. I've read your petition for conservatorship, and you see a couple things in your petition that I don't know if they were challenged, and I don't know who would challenge them. So my question for you is, if this is referred to district court, who's put on notice? Who has the right to challenge that? Do you know?
You know, it's been a long time since I practiced probate court, and I found it kind of boring, but, you know, I think that, you know, the procedures that I think have to be gone through, and I think they were gone through in our initial filing, was you have to, you know, comply with all their procedural rules, notice to this and whatever, and, you know, that's as much as I can tell you about it.
Okay, well, and let me be specific. In your petition that was signed by you, you indicate that that Mr. Lykins was in fact incapacitated under the statute. But he was not in fact incapacitated. There was not a finding of being incapacitated back in the spring of 2017, correct?
No, that's true. That's the problem. There should have been. He should have been referred to the district court in Clearwater County before 5/22/17, the date of that award.
Okay, so, but it's a chicken egg problem, because you're saying that he was incapacitated, but there wasn't a finding. So that's what I'm asking. How would we go about now getting a finding of whether or not he was incapacitated back in 2017?
How would you go about it? You would simply, vacate the award that was issued on 5/22/17, and proceedings would then be referred back to the Office of Administrative Hearings. And there would be then a determination at the Office of Administrative Hearings about whether or not there was fraud, as we allege, specific violations, fraudulent violations of 176.092 and 1420-2050, the procedural rule,
Would you have to, if we vacated, you don't even need to prove fraud.
Yeah, we do, because there are statutes of limitations that are dependent upon, they're going to start running when he received the protection of the conservator on 9/22/22.
Statute of limitations in the comp claim?
Absolutely. Yes, because, well,
I
It-
don't see that. I mean, if we vacate, and I'm not saying but let's hypothetically,
Yeah.
we vacate the stip.
mhm.
Now you just start as if there was no settlement.
Well,
End of story. And you
The-
have a conservator already. So the real question is, and I think this is what Judge Carlson is getting at.
okay,
We can vacate if he should have had a conservator in 2017 and he did not. Because the
Correct.
statute clearly says if you don't have a conservator and you are required to have one,
Yep.
the settlement is invalid. The
Yeah.
statute says it.
yeah,
So, and we can't decide whether or not he needed a conservator. That's the purview of the district court.
that's correct.
So, what we would need to do then, theoretically, is to send it to the district court and say, hey, please make a decision on whether or not Mr. Lykins needed a conservator way back in 2017, based upon what was known way back in 2017. Not what's known now, but what was
Right.
known then. And then the district court would have to make that decision. And then what Judge Carlson, I think, was getting at is, you went to district court last year.
Yep.
And got this man a conservator now.
Yes,
And Mr. Jung's client didn't have an opportunity to go in and say, wait a minute, we don't think he needed a conservator. Would he have an opportunity to go to the district court in this hypothetical scenario that I created, where we're sending it to district court, and say, I don't think he did need a conservator in 2017? And then the district court's determination would then inform this court on whether or not the petition to vacate could be granted.
I don't know that I can strongly disagree with what you're saying from the standpoint of the proceedings at OAH. Fraud is a automatic penalties. I mean, you're in. It's a violation of law under 176-225 subdivision 1. If we prove fraud, which I think we can, and I think we've detailed it out ad nauseum, and I can guarantee you that when you start taking some depositions of the people that are involved, you're going to get a lot of funny testimony, okay? We haven't seen one person in this case produce an affidavit rebutting our prima facie showing with exhibits 68 and 66 that OAH had nothing in front of it other than the infamous Mitchell report. We've not seen an affidavit from anybody. All we see are these fallacies. That's why I want to talk about those. Those are important.
So are you saying that Judge Dahlner did not have Dr. Odlin's report?
No, absolutely not. That is covered ad nausea in the memorandum, in the fraud analysis. To this day, You folks can do this with the technology, the Acrobat function of Adobe. We did it in our office. You're going to find in your analysis, or you can do it the long way, have somebody take a list of words and go through, read through the 29 pages, and you will not find mentioned in there prima facie showing, never mentioned. That's the burden of proof that they want you to forget about. They want you to forget about the fact that they have to rebut that burden of proof, not their version of what our showing is. We produce the showing, they rebut. There's not a mention of Exhibit 68, which defines that there was nothing ever transferred from Dolly to OAH. You can do that yourself. You'll never see a stamped in date at OAH showing a document coming over from Dolly.
Mr. Bailey, you're,
One more thing, Judge.
no, let me finish.
All right.
Please, thank you. So you're indicating fraud, and just so we're clear, you're saying fraud because of omission, fraud based on omission.
Absolutely.
That there were not documents attached to the stipulation so that Judge Dallner had enough information.
She was in the dark. The district court was totally in the dark. They'd never heard of Bobby Lykins.
Okay, but is there any statute or rule that requires that every single medical report be attached to a stipulation?
The rule of procedure that we cite and rely upon is quite clear. It's must. You must attach those things that support your position. The critique of the Mitchell report that we spent about 50 pages dissecting, which again is something that was never mentioned in their response of 29 pages, nor did they ever mention in their response that they're putting before you folks. They don't mention Dr. Odlin's name. The Mitchells hide, they give Dr. Odlin, who is the preeminent neuropsychologist that everybody is relying on, the insurers following his lead, providing the treatment, they're paying for it, and all of a sudden they want Dr. Odlin to be a dead man someplace. They don't mention him even in the materials they're submitting to you. That's what's so important about this fallacy of logic business. They want to define for you what you should know and what they should prove. They want to define what the prima facie showing of our group is, and they want to rebut, but they want to rebut their prima facie showing. That is what these fallacies of logic are for, is to mislead you as a court.
All right, well, here's what I follow your argument, Mr. Bailey.
Yeah.
I truly do. You got an attorney representing Mr. Lykins.
Yeah, who got $93,000 in fees.
Huge fee.
That's
And
right.
you got an insurer that, assuming Mr. Lykins' claim is as large as you assert, and which is substantial.
Absolutely.
They're saving $1 million.
Oh, at least.
And so they're all conspiring to hide this information from Judge Dallner.
Absolutely.
So I get all that. What you haven't shown, at least I don't think you've shown, is any evidence of that conspiracy. It's just, we can presume it based upon, it just seems so obvious. That seems to be your argument.
No, you can.
Where's the evidence? Well, let me ask you a preliminary question. Was there, or is there, a malpractice claim by Mr. Lykins or by his conservator against his former attorney?
There is, yes, and there would be. I mean, that's kind of the bottom
No,
drawer.
is there
of
actually one
culpability.
pending?
Yes,
Okay.
Yeah.
Started.
that's in the district court in Hennepin
So
County, yeah.
there's a pending malpractice claim.
Right.
All right. So, and I can understand that.
That's kind of the low level of culpability,
All right,
yeah.
so from my viewpoint, and I'm speaking for myself, not for
Right.
other members of the court, from my viewpoint, in order to vacate on fraud, not on he should have had a conservator, but on
Right.
fraud, you must prove that the opposite side, in this case, the employer-insurer, not your own attorney, but the employer-insurer committed fraud. And I'm struggling to see the evidence that they defrauded your client because your client's represented.
Right. And they're in bed together because my client's attorney wanted 93 grand and the other side wanted a few million.
Okay,
It's
I
not
understand that,
complicated.
But I get it, but I don't see the evidence that they are in fact in bed. I can see the evidence that seems to be the logical conclusion, but I don't see the evidence that it's actually true.
Well, we have a burden of proof. I don't need to prove in this court. All I got to do is make the prima facie showing. They don't want to let you even get to that level. They don't want you to understand that that's all I have to do in front of this court. They want to tell you that they have some ability to define what my claim is, and they will rebut not my claim, but their version of my claim. That's what these fallacies are about. That's why these things that you are just talking about, you will not find in their response, 29 pages, a reference to 1420.2050. That is the procedural rule that is one of the linchpins of the fraud claim. They mention 176.092 in 2 pages, page 12 and 18, but they don't refer to the specific provisions, 176.092 subdivision 2, that are the critical ones that they knowingly refuse to comply with.
Okay, and I follow you, I do, but, I get prima facie.
Yep.
And that's what I'm getting at.
Right.
Where's the prima facie evidence that the employer-insurer intentionally misrepresented by omission something when the employee had their own lawyer?
Well, because of all of the conduct, you have to presume that lawyers, as I talk about when we refer to the Code of Professional Conduct, you have to assume the lawyers kind of know the law. They kind of know there's a, when you're dealing with,
That's what I'm getting at.
yeah.
Can't the employer-insurer presume that their opponent, the employee, his lawyer, knows the law?
Absolutely.
Okay, so.
Yes.
So then, if the employee has an attorney who presumably knows the law.
Right.
Then they're just representing their client. Now, maybe they should have said something because the statute says they're supposed to.
But-
Maybe they should have said something that, hey, this guy looks like he might need a conservator, but the employee's got an attorney to do that too, and he's not doing it, so maybe the employee must know him better.
No, you're missing the point. 176.092 subdivision 2. Look at the chain of responsibility. It's specific. The last person that has the knowledge of this man's condition is the insured. They have the last responsibility to refer that man to the district court, and they didn't. And they knew that his attorney, Mr. Lykins' attorney, wasn't going to, because he had signed the document on May 12th after everybody had received Dr. Odlin's infamous 329-17 letter that detailed out what a nuts case this deal was. And everybody knew that. And that's the reason that Mary Hager, who's a woman I trust, she's bailed my butt out a few times, she wrote the memo that they don't even want to mention. That's another document that is not referred to, in the response.
Mr. Bailey, this case is complicated.
It is.
Well, it's right, it's complicated for a number of reasons, but there's, professional misconduct that you talk about at length. There is malpractice, which has been referenced here.
Yes.
There's your claims for fraud, and then there's also the claims under 092. So dealing with just what we can talk about here and what we can deal with.
Right.
I agree with you, under 092 sub 2, there is kind of a chain of defense.
It's specific.
Right, but it goes beyond the employer and insurer, it goes to OAH and even to the.
Yeah. Eventually, if the judge gets wind of it, which she would have if she hadn't anything in front of her, but the Mitchell report was nothing, that's a worthless document.
And I understand how the claim under 092 and also the fraud to some extent go hand in hand. But if I'm understanding your claim of fraud, again, it's the omission, fraud by omission.
Yes.
But in order for you to be correct, you need to show, there needs to be evidence beyond it's obvious that everybody was working together. It's not just fraud by one party. You're actually claiming it's fraud by both sides. Am I correct in saying that?
Yeah, and I think if you look at, say,
You need to stay on the microphone.
Oh, okay.
Thank you.
if you look at let me see, if you look at the synergy analysis, which is part of our document, part of our memorandum, if you look at the mechanics analysis, particularly the synergy analysis, you'll see this really weird exchange of letters. You know, you have Mr. Ellig sending his, fee petition to the Dolly. Now, they know that's never going to get to Dolly because he sends it on the 18th. He sends a copy to Mary Hager, and, Monday, May 22nd, whoever the judge was, is signing the award, okay? Now, if you read the specific discussion in that synergy analysis where it talks about these weird letters going on, why all of this, mystery about, they know they could call the judge. They know this stuff. The insurance company's attorney sends the letter over to the judge on the 19th, okay? Ellig, the attorney for Lykins, sends his letter on the 18th, and he sends a copy and a specific instruction to the insurer's attorney. Specific instruction. It's in the exhibits. Make sure you attach this to the award, to the stipulation, okay? Never got there, because everybody knows nothing is over at OAH that is buried, and I use the word buried in my analysis, is buried at Dolly.
So, Mr. Bailey, you believe you've made a prima facie showing?
Absolutely.
And that it should be referred back to OAH for specific findings to a
Yeah.
preponderance of the evidence?
Yes, because you don't prove fraud here. We have an obligation to make a prima facie showing. They have an obligation to specifically rebut. They have an obligation to go and talk about the synergy analysis. They don't talk about it. They don't mention it in their 29-page response. They don't mention any of these things, and I'll put this on the record. They don't mention in their response prima facie showing, Exhibit 68, Exhibit 66, the specific provisions 176.092 subdivision 2, where their responsibility lies. That's very readable. A high school kid could read that and understand it. They don't mention 176.092 subdivision 3. They have two references to generically 176.092.
We understand that
Okay.
the mounting evidence of omission is so overwhelming
It is.
that it leads you to conclude that you've made your prima facie showing.
Yes. And I will continue, if I can, with the list of things they don't mention in their response.
We do have that in the exhibits and in the arguments that you've had.
We don't. No, you
Paper.
don't. You don't have this. This is the information that you would be able to generate yourself. And I would appreciate the opportunity to get this into the record, what they do not even mention in their 29-page
I will allow the
response.
time, because we're 11 minutes over, for you to make a list here today in front of us of what is being omitted.
Yes.
Without conclusions as to why
Right.
or speculation.
Absolutely.
So go ahead and
All right.
list.
To continue, we were talking about their handling of 092. Big time, Dr. Odlin, his name is not mentioned.
And we've said that before. I
Yes.
asked you and you already told me.
Yes.
Thank you.
The Mitchell critique, where we analyze about 50 pages worth of
Correct. The
her
Mitchell
report,
critique.
not mentioned. 1422.050, the procedural rule that is the linchpin, not mentioned. The analysis of Dr. Odlin's letter of 329.17, not mentioned in their response. The letter from Ellig to DeVerne, the May 18th letter saying, hey,
I
here's
know
how.
the letter, so I'm asking you for a list because you are
Yep.
12 minutes now over.
All right,
If you want to have the opportunity to
All right.
complete that list,
okay.
just
The May 18th letter is
bullet
mentioned
point it.
on one page, page 19. That's it. Okay. There's no mention in any of the exhibits or any of the 29 pages. There's no mention of Exhibit 17, Exhibit 16, and Exhibit 12, all of which,
we know what they are.
okay.
They're all omitted.
All right.
Thank
There
you.
is no mention in the 29 page of the synergy analysis, which is a critical part of our showing.
You've
There-
mentioned that
There's no
already.
mention of the second stipulation analysis. There's no mention of the manipulation analysis. There's no mention of the fraud analysis generally. There's no mention of any of the components of the memorandum generally. The brief discussion, the authoritative sources analysis, the statute and rules analysis, the circumstantial evidence analysis. There's
So
no,
what you're saying, again, I want to stick to the exhibits that you say are omitted.
these are, they
I
are not
know,
talked
but
about.
But you're repeating yourself.
No, I'm not. I'm referring, these are all different parts of our showing that establishes our prima facie case.
Mr. Bailey, I'm not here to argue with you. I'm here to listen to your
Yeah.
arguments. I would like you to bullet the specific exhibits that you believe are missing, and you've done so without comment as to why you believe that rises to a level of a prima facie showing. You've already made that argument before, so just list the exhibits.
I think I've listed them all in just what
Okay.
I just did.
Okay, so you've completed that. I'm
I
gonna,
believe I have.
okay, I'm gonna stop you right there then. Thank you. Either of you have further questions?
I'm
No.
good, thank you.
Okay, thank you. You may take a seat. Mr. Young, why don't you come to the microphone? We'll give you ample opportunity to move forward with the same time allotment.
Thank you, Your Honor. I appreciate that.
Did I say it wrong? Oh, boy. You know what? I have to tell you that I am consistently saying your name correctly, and I apologize.
So in my family, we pronounce it with a hard J,
Mhm.
but my brother is different. And so, I don't really react differently to Young, or Jung. That's me. I'm here.
So, Mr. Young, you're going to
Represent my
assume that I am
clients.
like your brother here for purposes of today's argument? Okay.
Right.
I'm going to basically start right off the bat. And I have a question for you.
I'm ready.
If we were to refer this back to district court for a finding of incapacitation retroactive to the date, let's say, that the settlement was entered into, only looking at that evidence. And at that time, there is a finding by the district court that there was an incapacitation as that term as defined by statute. And that was missed by the attorneys, by the judge. Isn't that, or why is that not a classic mutual mistake of fact for purposes of coming back here under the fondness factors or on any petition to vacate with a prima facie showing?
Well, first of all, I don't think this court has authority to make a referral to district court under MnSTAT 176.461.
I believe it's vague, and I understand your thinking on that because I can read the statute more than one way. But if I were to refer it back to OAH for the purposes of referring it back to district court, yeah, I would be, let's say, and I'm not saying we're going to do that, but that would be more in alignment with how the statute is looked at today.
I
Correct?
don't think the district court has the ability to go back and make a determination as to what happened in 2017 and
Why not? Because the evidence would be submitted between the date of injury up through the settlement. And
Because-
why couldn't there be a retroactive application of incapacitation? Or are we to assume that there is, in fact, by the declaration in September of 2022, when it was found that the employee was incapacitated, that we can retroactively apply that?
First of all, I think the purpose of the court when you go into an application is to decide whether the person before you is incapacitated. And you can't become a conservator for things that happened 5 years ago. So the court is deciding, does this person need a conservator now going forward? I can't go back and say, I'm declaring Judge Quinn to be the conservator in 2017. Go back and undo his financial.
couldn't that judge make a determination that there was enough evidence to warrant a referral at that time and one was not done so, and therefore they can retroactively make that finding? And if so, if that district court judge were to find that the referral should have been done, is that then a fraud? Because, or is it just a mutual mistake of fact that everyone made without a showing of intent to defraud?
No, because you're putting on to you're giving responsibility for parties to go back in time and figure out what they should have done. I'll answer your question, but I want to make sure we don't forget the fundamentals, that this initial petition for conservator did not assert that the gentleman needed a conservator to function in society or to be active. It's specific to workers' compensation.
It is.
And there is no such thing as a workers' compensation specific incapacity, which is what they're trying to
Right.
allege.
And the
because of
order
scheme.
for the conservator basically, is my understanding, at the final says that the court reserves the authority to make further determinations relating to the need of the respondent for further and more comprehensive conservatorship or guardian services. That's a nice opening for me, that there's a continuation of a need that they may be back into that court.
They could determine that the gentleman needs a conservator for greater purposes. The current appointment, and I'll quote, is being sought for the limited purpose described above, which was specific to come here and undo a stip. It was not to say this gentleman's struggling in his life, he can't function, he can't contract. And I just don't think we can forget the fact that I think this case ends if you read the reply brief.
I have read the reply brief, and so have my colleagues.
Yes, and I know you have, but they are not even asserting he's incapacitated. They're asserting he's incapacitated for workers' compensation, which is not a term in the statute.
And Mr. Jung, and I'm sorry to interrupt, but the question isn't whether or not he's incapacitated now. The question is, was he incapacitated back in the spring of 2017?
Yes.
So regardless of the current petition and order for conservatorship, the real issue is what should have been done back in 2017. And I think 176092 is pretty clear that if anyone, his attorney, SFM's attorney, OH would have had reason to believe that he was incapacitated, that it should have been referred to district court, right?
If that were the case, which was not the case.
So the
Nobody
question is
had
really-
reason to believe, yes.
Well, and you indicate in your brief that your client had no reason to believe.
That's right.
But you agree that even if his attorney at the time had reason to believe that this should have been referred to district court, and that is really what's important, is whether or not he was incapacitated at that time.
The fundamental question was whether he was an incapacitated person. If he wasn't, there's no reason to believe. So we know from the record, Your Honors, we know from the record he was not an incapacitated person. I think it's...
Why is that any different from Mr. Bailey arguing that we know from the record there's a foregone conclusion that he was incapacitated? So why is your argument any different that you know from the record that he wasn't? And isn't the fact that that determination by either of the prior attorneys or you two today could not be made? That's a finding by the district court.
I'll tell you why it's different, why my position's different, is because, for one, it's admitted in the reply brief that he can function and do contracts. It's admitted he can function in the other courts. He admits he passes his classes and can be an active participant in the bankruptcy proceeding. He admits he can be an active participant in his family law proceeding.
But Mr. Jones, the things that you are talking about happened after April and May of 2017. I think there was a bankruptcy class
Concurrent.
in July of 2017
Right.
that he had to do. I'm not familiar with that class or what level of
Right.
competency you need, but the rest of the stuff you referred to, including court proceedings, and I think there's maybe a real estate transaction, that come well after the spring of 2017. And the relevant time frame is through the spring of 2017 and not beyond. Do you agree with that?
No, I don't. In part, I do. Some of the things we reference are after, but some are concurrent. His participation in the bankruptcy proceeding was concurrent. And his records are concurrent. And what counsel notes, I'll just point to the court, page 104, they're admitting he can enter into contracts. They're admitting he can be involved in the legal process. That's an admission. And I think the description of the need for conservator in the initial petition for appointment is further an admission that he can continue to do these things.
To me, that just goes to the point of whether or not he's incapacitated requires a referral to the district court prior to the mediation.
This court.
Because everybody is, what I'm looking at the medical at that
Yeah.
point, between 2015, it was a horrific injury, correct?
It was, as described by Mr. Davern, catastrophic, which
Okay.
was always acknowledged to the court. Everything that we're talking about today was described in the stipulation for settlement, in the letter of the referral.
I'm
And
not
in
going
fact-
to, I'm not going to fraud or conspiracy theories. What I'm asking is, and because this is what I'm looking at, the physical disability of this person is going down as cognition is moving up because he's recovering. And I've got 2015 and all of a sudden 2017. The medical are kind of shifting. You're getting reports. Those reports, some of them are not provided to the compensation judge. But again, the referral should have been made, if it was going to be made, by a compensation judge. And the fact that you say there was no incapacity at that point, and Mr. Bailey says there was in fact capacity at that point, basically, it's a draw.
No, Your Honor, it's not a draw because there has to be information provided to my client that he's incapacitated. This is not something where we're requiring lawyers to read neuropsychological reports and interpret them. If you're going to open that door, Your Honor, that my client has to interpret neuropsych reports that do not say incapacity, who do not say he can't contract. I read this Odlon report. I've read it 5 times myself. I would not refer this person under 029 today because the questions asked are not about his ability to understand a contract, which we know he could, or to understand the process. And if you're going to task advocates like me, who are not doctors, to go in and say, I think this person needs a conservator, and I'm going to upset their life. If Mr. Davern had done that, would this employee have custody of his child? Would he have the ability to buy and sell his own home? I caution this court.
The answer depends on what the district court
Right.
will find.
Right.
I mean, again, the question, in my mind, the question isn't so much, was he or was he not incapacitated in 2017? The question is, was there some evidence, some reasonable, sufficient evidence to cause somebody in the process, whether it was Mr. Lykins' attorney, whether it was SFM's attorney, or the claims adjuster, somebody in the process to go, you know what? I'm not so sure. Let's send it to district court just to be sure.
Well,
That's the way I analyze it.
I'm concerned with the court's described of some sufficient evidence. I think you have to have someone telling my client or something that they observe themselves obvious, that this person isn't understanding what's going on. He's got dementia, he's in a coma. It's more than...
Well, that's what I mean. Evidence that points to that. I mean, I printed it out because it's not something that we deal with normally. I printed out the definition of incapacity from the probate statute.
Right.
Lacks sufficient understanding or capacity to make or communicate responsible personal decisions. So is there something in the ODLOG report, I'm mispronouncing that doctor's name,
Odland.
Odland's report. Is
So,
there something in there that would cause somebody to go, maybe? That rises to an issue in my mind. I'd like a district court judge, I mean.
You're opening a big...
Do that.
No.
That's really the question.
A reasonable lawyer would not do that in my
And
view.
that's what I want.
But I think, so the questions that Mr. Ellig asked are enumerated. And they tell you what he's trying to argue. Can he still drive? Does he need medication? Should he have chiropractic? Is he unable to work?
Was he at MMI?
He was at MMI per Dr. Hoyer. And that was
Dr.
filed by my client, very open. I mean, you have to find some irregularity to vacate a stip. And even here, there's none because There has been no identified false statement, not even alleged. There's nothing that's that someone's relied upon. And here's an important admission. I have it in here. They acknowledge that any time Mr. Ellig could have filed any report he wanted to. And counsel admits in his brief, my client did not obstruct or block anything. So this is really a question of what Mr. Ellig chose to file. If he thought something that SFM was insufficient, you guys have all practiced law. The advocate for the employee files the document. Hey, I think Judge Millen or Judge Dahlner or Judge Vallant needs this additional document. Further, judges frequently in my life had said, I think I need more information. They can ask for more. And so if this question of did Dahlner have enough information, and he hasn't even alleged she did anything wrong, that's an abuse of her discretion standard. So this goes back to your question about what claims are pending. And again, I'm not suggesting there's malpractice by anybody, but they have. And if there is a remedy, the district court of remedy is available that Mr. Ellig can defend.
You know, I understand you move towards that conclusion, and that may very well be the conclusion. But in the workers' compensation system, there is setup for checks and balances. And I just think of something when there's a dispute as to whether or not the employee is entitled to rehabilitation. Isn't there a referral to a QRC to make that determination on eligibility before you move forward with those services? And so you may, through your client, and I represented employers insured, have been the advocate to say, no, they're not eligible, they're not entitled, and for the employee's attorney to come forward with the opposite, but it still moves forward through the statute. And right back to a referral for a determination as to whether or not the employee met the legal standard of incapacitation is under the purview of the district court. It's not up to you, it's not up to Mr. Bailey. And I would say if we find that it's not up to us, the statute does give us the remedy to move forward, and I'm not saying we are, to move forward to refer it to OAH for the purpose of referring it to district court. And the test will be whether or not a retroactive finding, either way, that he was or was not incapacitated at the time of the settlement would be under the jurisdiction of that district court.
This court has to decide what triggers that obligation. This court has to decide how to interpret the statute of 092. This court, I think, should be very cautious about vague statements about general limitations in executive function that are not an answer to the question or advise, for example, my client, a statement like, he is incapacitated, he can't understand, versus saying generically that there's limitations in function. If you're going to do that, how many head injury cases are going to end up referred out when there isn't someone saying he's incapacitated? And let me just mention, counsel referenced the Grover case about sex abuse cases, which I don't think applies. But even if you did, that's a case where someone came to the teacher and said, someone's grabbing my son's bottom. Didn't say there's something weird going on vaguely. A specific declaration was made twice to that teacher. So if, for example, we have the QRC coming to my client saying, this gentleman does not understand what's going on, or the doctor says he's unable to understand basic stuff, does not say that. So I do caution this court, be careful to not open a door where my client's going to be upsetting these men and women's lives by finding incapacity based on, are you really going to ask lawyers like me to interpret between the lines and neuropsych testing to decide that question, whether I'm going to open that door or not? I don't think you do, unless it says it.
Mr. John, a couple of things, and I'm going to try to make this a question. Being referred, 092 only requires a referral to district court. It doesn't mean you're incapacitated. It just requires a referral to district court for a determination on the issue of capacity. A referral to district court doesn't deprive anybody of custody or the ability to make decisions. It's just a referral to district court, correct?
Depends on what the judge decides. It could.
A referral to district court does not upend anybody's lives. Your client, and you would also agree that the statute actually requires it. It says that they shall refer it over to district court. It's not discretionary for your client if they, or for Mr. Lykins' attorney, it's not discretionary. They are required to do that by the statute if there is reason to believe that they may be incapacitated.
I am not disputing the plain language of the statute, but I'm going to tell you, make sure before my time runs out, and I'm happy to answer questions, nobody suggested in 2017 that this gentleman was incapacitated. Ms. Hager did not suggest it. 2 QRCs did not suggest it. None of the physicians suggested it. Nobody suggested to SFM or my client's employer or the employer insurer that he was incapacitated. And he had a normal process. He had a 37-year lawyer who had calls, represented him carefully, and I think probably very well. You talk about the fee question, that's not about us. But he did his job very well, I think, and worked very hard to represent this gentleman. There was no litigation. My client never met this fellow, didn't take his deposition. It was not in litigation. It was an admitted case. And of course, someone said, oh, they saved millions of dollars. No, they guaranteed this gentleman an amount of $438,000. Let's say he would have passed the next day. I mean, settlements are volitional. There was no pressure. And don't forget, this was a slow process, no pressure. He went to the mediation, didn't settle. After the mediation, decided to settle. It's a choice. His lawyer advised him. They could have done otherwise. And he signed the agreement saying, I understand it.
We understand.
Okay.
We understand that.
It's
I
important.
have a question about 176381, references of question of fact. You caution us not to move into a direct referral to district court. But if I go to 381, I can refer a matter back down to OAH with specific questions. Is that not the opening to move back into OAH, who then by statute can refer this to district court for the purpose of finding out if Mr. Lykins was incapacitated at the time of the file, at the settlement?
I have very significant concerns about that.
I know you do, but do you believe the statute prohibits us through 381 to move forward?
I will say on the record that I do not think you are empowered to do that.
Tell me why, where in the statute does it prohibit?
461.
461 says
Which
what?
says in certain times you can send this back to Office of Administration, OAH for factual findings. It does not say you can send it to district court. And I'm concerned with
I'm not saying to send it to district court. I'm making referral back to OAH.
Who then?
Who then?
I understand. I think that the buck stops here, that this court decides if there was an irregularity that makes this decision void or voidable. And I think that this court can look at the record that presently exists, that both sides have opportunity to provide. I don't think any referral is needed to district court because, among other things, the admission contained in the documents that nobody suggested said this person's incapacitated at the time.
Oh, but again, you're jumping
Oh,
again.
I'm
I had
repeating
it.
myself. I'm happy to keep going on your
Well,
line here.
here's the question, you know, when we move back into a referral to OAH, and you're saying you would caution us, we're asking them to make findings of fact clearly within the purview of an original jurisdiction document, the petition to vacate. What's to stop Mr. Bailey from, let's say you're correct on everything, and we deny the petition to vacate. Tomorrow, he files another one. The next day, he files another one, and so on and so on. We have had that happen. What's to preclude him from moving directly for a filing back into district court and getting a retroactive determination of whether or not a referral for a determination should have been made? And I don't know how far the district court would go to even make the determination if in fact he was at that time incapacitated.
Well, first of all, if this court decides there's not good cause to vacate, that's law of the case. And I don't know that the district court is willing to go back and make a determination based on the conservator statute about whether he needed someone 6 years ago, because you can't appoint someone retroactively. And third, the employee does have a civil remedy and he's pursuing it. And if he wants to pursue a claim against Mr. Ellig, not that I'm on the bandwagon of the merits of that, he has it. So if there is a problem with, he doesn't like his settlement, he can pursue against the civil action he's pursuing, which again, I'm not saying has merit, but that's, you know, if he's upset that his client, that Mr. Ellig didn't explain this well enough to him, which seems to me he did, or wants to pursue that, that's a civil remedy. I don't think this court has to worry about whether you can get the district court to refer, to make a retroactive finding, because this court has to decide whether something went wrong that violated the statute to make the case void or voidable. And I think they had their chance to prove fraud, didn't find one false statement made by our client. He had the chance to put forth evidence of incapacity, but rather admits in his own brief at page 106 and 107 that he is capable. He's making contracts. I won't go over that again.
All right, so let me enter.
Yes.
I want to get back to Chief Judge Millen's question, because this is what is vexing us on this particular issue. Let's assume hypothetically that we disagree with you, that there is sufficient evidence to give rise to the question of whether or not Mr. Lykins was incapacitated in 2017. I mean, I understand your arguments, and I think they're good ones, but let's say I disagree with you. All right, it should have been referred. All right, that's what we determined. It should have been referred. Not that he is, but at least there's a question. What's the mechanism? How do we get there? We can't decide incapacity. We can, only a district court can. So how do we get it to district court for that question? And we're allowed to refer matters to OAH for fact finding. They can't make that fact finding either. We're allowed to vacate. Vacate's not even the right word.
Void or voidable under Sondrel.
Under 521, not even under Sondrel. 521 says any agreement to settle a claim is not valid if a guardian or conservator is required. And we can't decide whether one's required. The district court has to decide. So it's really, there's almost a hole in the statute as far as our authority. But if we look at 381, which allows us to refer matters to district court, and then we look at the other statutes that say, or to OAH, the OAH can't make the fact finding, only a district court can make the fact finding. Can't we, I mean, again, we're assuming that we disagree with your argument, so that's an assumption that we have to get.
Hard for me to live with that, Your
Yeah,
Honor.
so, and I know you're not gonna argue, or you're gonna argue against that, and
Yes.
you already have, and I think quite well. But if we get past that, how do we get it to district court to make that finding? We can't command the district court to make a finding, but that's what we
No, you
just ask
can't.
them.
Right.
Please find whether or not this man did or did not need a conservator in the spring of 2017. Can't we do that? That's our question.
I'm not sure that you can, and this is how I'll answer it. You cannot award a conservator, but you can look at the record you've been provided and agree that they did not meet their standard of finding an irregularity of a violation of statute or other violation of 092. I think you can decide that, given that nobody had said he's a incapacitated person, and given the admissions I've talked about, which I won't repeat, that the showing, the burden that the employee's conservator must show has not been met. That's what you can do. You can't say whether he gets a conservator, but you can order that he hasn't met his burden of showing good cause.
Or we can say, based upon the evidence before us, he has not made a prima facie,
You can, and he hasn't.
and he can file tomorrow with new evidence.
Well, good luck to that, but
No,
yeah,
I
I can't change the statute as it exists.
Well, none of us can. I mean, we're here to interpret it.
Right. Most people who are represented by competent counsel, when they realize the court has told them no, don't come back. But people pro se, I know they do come back to this court. I can't change that. I'm not a legislator. But I think this court can make a determination that good cause has not been shown, and I think it's overwhelmingly the case that it hasn't.
And you're saying if we stay in our lane, we have to deny the petition to vacate?
Yes,
Based
I
on the
am.
evidence and the law?
Yes. Based on what you have before you, it's certainly clear to me. And again, including this apparently explosive report doesn't say he's incapacitated. And I won't repeat myself other than to say that this court does have the authority. The statute gave this court the authority to vacate or not vacate. No other court. And of course, that can be appealed to the Supreme Court for various reasons. And further, the last thing I want to make sure, unless I answer your question, is the statute is very strong. In the case law, I think it's the Perez case, is that we very rarely overturn judges for not doing things right. She didn't do anything wrong. She had a very well articulated description of the case. There's been no allegation that the STIP misled her or that he was not telling the truth when he says, I understood the agreement. So I don't see any irregularities that warrant vacation. And this settlement was understood by him. I won't get into the brief about that. As like his other contracts that counsel said he's very able to do. This is one other contract that he was able to do.
Do you have anything further? Thank you.
Thank you for the conversation. I very much appreciate it.
Judge, I would like to be able to respond.
I will give you 2 minutes because that's how much time Mr. Jung got over your initial
What you're
overtime.
seeing is exactly what I told you you're going to see. He is defining our claim, and he wants you to accept his definition. This is a simple case. There's 2 procedural rules. There's a statute, and the statute is clear and the procedural rule is clear. And you have the authority to refer this matter back to OAH for purposes of dealing with the prima facie showing of fraud, which we have made, which they do not want you to be aware of. And they want you to believe that they define our claim and they will then define what they're going to rebut. That's why you don't hear them mention any of these things that define in detail what they are not wanting to cope with, because they can't. I just want to take a deposition of a lawyer, and I think it's going to be a hayride for him. He's got problems. There's going to be tons of questions that he's going to get really tangled up about, because he's not a dumb guy. He is a guy that knows exactly what the law is. He can read those statutes. He can read that procedural rule. He can read the Mitchell critique. He can know that that thing is a piece of junk, you know, and that's what this is all about. They don't want you to refer this back to OAH on the basis that we have made a prima facie showing for fraud, because we have, and they cannot rebut it. There is not one affidavit in here to say that OAH got anything from the Department of Labor and Industry. We have an affidavit. They have an obligation to rebut. If this were a motion for summary judgment, they lose. You don't rebut facts, particularly facts and affidavits, with argument. 0. You lose. So they lose that automatically. They know exactly what's going on here, and all they've got to do is read the statutes, read this stuff, and actually pay attention to what's in those documents.
Thank you, Mr. Bailey. We understand the arguments before us. There'll be a decision.
I just want to ask a question that's going to have a 1 or 2 word answer.
Yes.
What lawyer do you want to depose?
I want to depose Mr. DeVerne.
Okay, that's what I thought.
Absolutely.
Sure.
I mean,
Thank you.
Ellig's going to be
Thank you.
easy. I know how
no,
he works.
Mr. Bailey, I appreciate your passion for this argument, and I appreciate the arguments and your discussions that we've had with both you and defense counsel today.
Yeah. And,
I have no, I'm speaking.
okay.
You're done. You're done. You can
All right.
take a seat. I want to basically say that the record is now closed. There'll be a decision out within 90 days. We have the full record and the full arguments. They're live stream. We can go back and pull something up if we think that we need to rehear it again on today's presentation. Thank you both very much. That concludes this. Thank you. Charlie.
I'm Larry Peters.